Ladies and gentlemen, once again, welcome back to NDTV's flagship series, India Through the Eyes of Its Icons. Joining me and Maria today is somebody whom you can call the doyen of the bar and the bar of the legal kind, and somebody who has virtually seen the evolution of legal jurisprudence all through the independent India's history, beginning sometime in 1950s. Mr. Venugopal, welcome to NDTV.
Thank you.
So, you know what he said right at the beginning,
Yes.
that brought a smile on your face.
Yes. Bar.
The bar.
Yes.
So when your journey began at the bar
Yes.
in 1954,
Yes.
it was the Mysuru High Court,
Yes.
which later became Karnataka High
That's
Court.
right.
You have practiced and appeared before each and every High Court of India.
Except one or two.
Except
Otherwise, nearly all. During all these years.
So tell us about that, sir. How has the journey been?
See, I was never thinking of law as my future. And I was in the Madras Christian College doing BSc Physics. But then, unfortunately, when the selection for the final exam took place, I was ill. Therefore, I couldn't write that. And I was sitting at home. And at that time, my father saw an advertisement in which they said the LLB, 2 years, without being a graduate. Therefore, I am, I think, one of the exceptional lawyers in India who is not a double graduate, because I was not, the question didn't arise. I did my LLB in 2 years. That, of course, gave me a start, more than the others, by advancing my career by 1 or 2 years, because I didn't have to do the arts course, which would be normally 2. At that time, it was only 2 years. And from there, I was working with my father. And my father had appeared in the AK Gopalan case. And that was the first big constitutional cases. And that attracted attention all over India. And his name was made by that one judgment. And thereafter, he was practicing in practically all the high courts and the Supreme Court, appearing in the Supreme Court in most of the big constitutional matters. And when he died, at the reference, I think it is Attorney General Nirande who said that he was the biggest constitutional lawyer in the country during his lifetime. Therefore, I stood on the shoulders of a giant, because he took me under his wings and ensured that I would get briefs, which he was to handle to prepare those cases. And that gave me an excellent grounding. And today, if I am a lawyer of some consequence, it is all on account of my father.
Mr. Venugopal, many would say the same things for you, that you are one of the finest legal brains in this country.
I don't know. Anyway, it was by sheer accident that I got into the legal sphere. Mm-hmm.
Tell me something, Mr. Venugopal. You have literally seen the jurisprudence evolve in this country after just the beginning decades of independence. You have been there either at the high courts or at the Supreme Court itself for the last 6 decades or plus. That's a very long time. How do you see this evolutionary journey of independent India's legal jurisprudence?
See, so far as the judges of those days were concerned, they were very independent. And this hurt Nehru very much. And Nehru made some very strong statements, saying that they cannot sit as a fourth house of parliament. Mohan Kumar Mangalam made a scathing attack against the judiciary, because land reform after land reform was struck down by the judiciary.
Yes.
And perhaps they belong to a very elitist class. And for example, Justice Vaidalingam had vast lands in Tamil Nadu. Therefore, their approach was totally different at that time. Now, every one of those laws which had been struck down had to be reinstated by an amendment to the Constitution. And that's how Article 31A, 31B, 31C all came into existence. And with that, so far as the judges were concerned, they were put in their place by the executive of that time. Now, Nehru threatened to pack the court, but that became unnecessary because from much later, they fell in line. And so far as they are concerned, they became a political center of the country through the public interest litigation. There is no sphere of human activity in which the judges were not concerned. And therefore, you find strange judgments where part of governance is taken over, as it were, by the present Supreme Court judges for the last about 2 decades.
So you say that judges back then were fiercely independent. What change have you noticed? I mean, has that independence grown? Has that isolation grown? Has it decreased? Has it gone down? Have judges become more pliable? What do you say? What is your comment?
See, there are quite a few judges of the Supreme Court who are very independent. And today you will find that they are delivering judgments, very balanced judgments, and if necessary, fully against the government. But there is a small section, very small section, which are, I think, quite favorable to the government. And those are the judgments which have resulted in denying bail right and left to those political or other detainees. Or we know, for example, 1 or 2 judges, perhaps you know in advance that you will not be able to succeed if you are attacking government. But otherwise, there is a good section which is wholly independent.
There has been a view on nature of engagement between the judiciary and executive. Of course, there were certain, photographs which went viral with regards to the former CJI having a guest in the form of the Prime Minister at home. So the question is, should a CJI and the Prime Minister meet? Or should that be...
I have a little...
why should they not meet?
I have a little embarrassment. For the simple reason, I have known Chandrasekhar, who you are referring to him, I think from when I had appeared in the Bombay High Court against him, in where he was appearing for the government as an additional Solicitor General of the state, at the state level. And he won the case. But he was brilliant. And when he was making a choice as to whether she should accept a nomination to the courts, his father, Justice D.Y. Chandrasekhar, before whom I had been appearing regularly in the Supreme Court, asked me, what do you think? I told him, look, personally, I think he's a brilliant lawyer and he will rise to the top of the profession if he chooses a profession. But he chose the judiciary.
The judgeship.
And when I met him at one of these meetings, I told him, how did I know at that time he would become the Chief Justice and rise to the highest position? If I had known that, I would have said you should join the judiciary.
And so among the judges, because from your chamber, you have had union ministers. Your juniors have been chief justices, several senior advocates as well, and, top legals, including Rohinton Nariman. Who do you think has been the real torchbearer of your legacy?
I think Rohinton Nariman, and now Vishwanathan, who was with me for a number of years. He's going to be a Chief Justice in due course for a year or so. I found, during the short period of a few months, totally independent. And I think he had the advantage of sitting with Justice Gawai, who is equally independent. and therefore I'm having very high expectations for him.
Mr. Venugopal, Justice Chandrasekhar himself has actually said, and quite a few other judges of the Supreme Court have also said that if you give orders against the government of the day, you become independent. But it should not be expected of the judges to play the role of the political opposition. We are not the political opposition, we are the judiciary of the country. What are your views on this?
See, I don't think that requires any sort of taking a position, because it's obvious that you have to be balanced. You have to decide every single case coming before you with strict honesty and independence, and without any concern as to whether it is against government or for government. And therefore, if you are independent, then so far as the case is concerned, it's decided only on its merits. No other factor comes into play in your mind. And that is required. And therefore, to say that if I hold against, the people would expect me to hold everything against government is not at all correct. Nobody expects that. They expect you to decide independently and with restraint and total approach to a case on its merits and nothing else. Therefore, there is no question of the people wanting you to decide against the government. They want you to decide correctly, and in appropriate cases to decide
Appropriately.
Against government if necessary.
One view is that perhaps the judiciary has, in certain cases, through its reviews, has taken over the role of legislature and executive. That it appears to be so overpowering when it is actually the legislature, the government of the day, which gets elected from the people of India, while judiciary enjoys that kind of power.
You see, so far as this is concerned, a former Chief Justice, that is Justice Bhagavati, P.N. Bhagavati, in London made a statement that the Supreme Court of India is the most powerful apex court in the world. The reason is they have practically, according to me, taken over a part of governance. You will find, for example, just take this pollution. Who is to decide as to what steps to take to control it? Now, in this case, it is the Supreme Court which has been laying down and deciding today gap 3 or whatever that is, or 2 or 4. Then where is the government? Is it an exercise of executive power or not? But then the people welcome it, because somebody has to do the right thing. And if the government is quiescent or not active, then the Supreme Court steps in.
But where is the separation of power then?
That is true. The separation of powers does not exist in the cases of PILs, where the government has been looking at the cleansing of the Ganga or the Yamuna and so many other, then laying down rules for adoption of children, then cleansing of the Taj Mahal, because it was getting affected, and the marble was yellowing. And I think this Justice, one of the judges, he would send for the secretaries of government and say, look, don't you think we should do this? And they will say yes. And by that time, he would have made them totally bound by whatever he wanted to do. And that's how he was able to do a remarkable thing. Therefore, what they are doing is good. But if you ask whether it is constitutional, perhaps no court in the country should be the most powerful in the world.
Mr. Venugopal, you just mentioned that first Prime Minister, Mr. Nehru, got very enraged by some of the judges of the Supreme Court and said that, they cannot take over both the houses of the parliament. We see that tendency, we see that happening quite often with the powerful executive in play. Do you think that whenever it comes to sort of issues that are closer to the heart of the government of the day, it becomes a personal, or it becomes a clash of institutions rather than a clash of what is right and what is wrong?
That is true. See, the government has policies, and so far as they are concerned, they would ensure that those policies are implemented to the full. But it still has to pass a test of the Constitution. The fundamental rights have been interpreted widely. For example, take environment, cutting of trees, or climate changes. The court says, look at Article 21, the right to life and liberty. And the right to life will be affected, say, for example, by the pollution. Now, therefore, we are entitled to take it over and ensure that, so far as pollution is concerned, it is reduced to the maximum, because the health of the people is involved. Similarly, the fundamental right to life is used for any number of judgments because we believe that is necessary for the people's good. Therefore, all these things are very good, because where government fails, the court steps in.
Do you think there have been times when the two responsibilities, or should I say duties, of the two institutions have not been done properly? Do you think there was this moment where you realized that the Supreme Court did not really rise to the occasion?
As one of your favorite, colleague itself, he himself wrote, Supreme Court is supreme, but not infallible.
That is true. No, for example, you take ADM Jabalpur. There the Supreme Court's image touched the nadir, where they were not prepared at all to strike down the gross injustices brought about by the emergency. They said the right to life doesn't exist. And Justice Khanna, the sole dissenter, asked a question. Suppose a policeman threatens his neighbor saying, I'll come and see that you are finished up tomorrow. Cannot that man come to us and ask us to intercede? And the Attorney General, Nirande, said, Lords, according to whatever is my thesis on this, I have to say that the man cannot possibly be protected by you, because he has no fundamental right to life, and therefore you cannot interfere. Perhaps if later he can ask for compensation, his family. Therefore, this is the extent to which they were prepared to go during the emergency. And they were cowed down, as it were, the majority. And one of the Chief Justice later admitted that I made a big mistake.
Mr. Venugopal, let me bring you to the current times. There has been a lot of consternation apropos the bail matters. These are matters currently also pending in the various courts. Supreme Court has done a lot of talking that bail and not jail is the right of under trial, and that bail is fundamental to liberty. And fairly enough, in any evolved jurisdiction across the world, Mr. Venugopal, to incarcerate a man without a trial, surely for sure, besmirches the entire process of the law. Because you account me for guilt and then you give me punishment is the basis of entire jurisprudence. That's how it has evolved. Why do you think, despite all the pestering, lofty talk, continuous talk by the Supreme Court on the bail matters, somehow the jurisprudence on bail has not been, what can one say, has not been appropriately reflected in the judgments of the courts?
See, I think recently, last few months, the pendulum has been swinging to the other side, being more liberal. But otherwise, we knew that if a bail application came before a particular presiding judge, it would automatically be refused. And that was being done. And unfortunately, again and again, cases were being listed before that particular bench. And they were being listed, all these political cases, one by one. But then, recently, there has been a slight change. And they have been more open and liberal. And therefore, in those cases, they have been granting bail. And that is how you find all these AAP ministers and the chief minister have been released on bail. And therefore, this should never have happened. They should never have been incarcerated to this extent.
In Parliament, we heard a landmark debate on 75 glorious years of our Constitution. You know, it was a rare occasion where parliamentarians did speak with a lot of substance and also, you know, political attacks and counter-attacks. But sir, there was this point that was made by one of the ministers which, with regards to the amendments in the Constitution, that during the Congress regime of 65 years, there have been 77 amendments. During the BJP regime, which is Prime Minister Modi, and before that, Atal Bihari Vajpayee, 16 years and 22 amendments. And the charge was that in those 77 amendments during the Congress regime, they were done not in the interest of the people, but in the interest of the family. As a leading constitution expert, what are your views?
No, I don't agree with that, because I have the complete list of amendments where the courts have struck down a large number of amendments, but otherwise the Supreme Court has been upholding. Now, for example, take these land reforms. The Supreme Court has been striking down those laws in the early years of the Constitution based on the compensation and various issues. The interpretation of the court was you have to give market value. If you want to, the land reforms to operate and the land to be transferred from the zamindar to the tiller of the soil. If you give market value, I can go and negotiate and buy the best this. And where is the money coming from? Therefore, they had to amend it. And the Constitution, first to fourth amendments were for that. Again and again, amendments were made. Now, for example, Article 368, Amendment to the Constitution. A proviso was added that no amendment to the Constitution shall be called in question in any court of law, which meant that so far as Keshavananda Bharati, etc. is concerned, they became only a piece of paper. Therefore, that was struck down, saying judicial review is part of the basic structure. You can't say that whatever is made by the Constitution amendment has to be accepted by us. Similarly, the defection, anti-defection law, where the Speaker was given absolute powers. Therefore, I would not agree that so far as the 75 years was in the interest of the family. But during the emergency, there were laws only for the interests of the family. And that was so far as the emergency was concerned when Indira Gandhi's election was set aside by the Allahabad High Court. And when the matter was pending in the Supreme Court, when no stay had been, full stay had been granted by Justice Krishna Iyer, she was furious. And therefore, she went with, I believe, with Mr. Siddhartha Shankar Ray, without consulting the cabinet. While under the rules of business, the cabinet had to agree to the emergency. And went and met Mr. Zakir Hussain, I think, was the president at that time.
Fakhruddin Ali Ahmed. Fakhruddin Ali Ahmed.
Fakhruddin Ali Ahmed.
Fakhruddin Ali Ahmed.
And asked him to sign on the dotted line. And the emergency was declared.
Promulgated.
Then they passed law after law, by which every single finding of the Allahabad High Court was neutralized by amending the Representation of the People Act. And to cap it all, the right of deciding on the validity of our election was taken away from the high courts and not even given to the Supreme Court so far as the appeal is concerned. They said appeal will lie to the Parliament, and Parliament will decide whether I am disqualified. And she had an absolute majority. Those laws passed during the emergencies, I would agree was fully for the purpose of benefiting
Particular family. Thank you, Mr. Venugopal. Thank you for joining NDTV. I am grateful from the side of my viewers.
Yes.
As I said, the doyen of the Indian bar.
Thank you. Thank you.